May it please your Lordships, I think I was making what you'll be pleased to hear was my penultimate set of submissions. Doesn't tell you how long the last one will be, but they will be short. And this was in relation to there being a clear chain of reasoning. I'd taken you to our case at paragraphs 71 to 73. I was then taking you to our case starting at paragraph 77, page 87, right at the bottom, so it's really page 88. This was our response to the issues as summarised by the Court of Appeal with which the learned judge at first instance took issue. See page 55, which is paragraph 25 of the SFI. And the first one was not explaining why the meal on the 7th of August might not be at fault for the second episode, and we've set out a response at page 88, which your Lordships can see. We're just going to add to that as follows. Professor Pennington's evidence was that the possibility cannot be ruled out that they had two infections. In other words, the probability is that he had a single infection. And if you want to see where he put this, it's page 208 at the beginning of paragraph 4. So that is language. The possibility cannot be ruled out that Peter Griffiths had two infections, one starting on the 4th and the second starting on the 11th of August. In other words, he's acknowledging that possibility, but he's identifying that the probability is that it was one infection. That is consistent with his description at the end of the report. See the last sentence on page 208, in which he says, on the balance of probabilities, Peter Griffiths acquired his gastric illnesses following the consumption of contaminated food or fluid from the hotel. And in their written case, the respondent seeks to draw what it would say is another difficulty with the report by contrasting the possibility that there were two infections, i.e. the probability there was one, with the reference to gastric illnesses. And respectfully, we say there's nothing in that. Professor Pennington was distinguishing between the number of infections, 1, and the number of bouts of illness, 2. The second occurring, in fact, on the night of the 10th stroke 11th, it's paragraph 8 of the SFI at page 48. And on the basis that there was a single infection, the meal of the 7th of August cannot have been the cause of the second bout of illness, because there was one infection. So it's a complete answer to the complaint as to not explaining why the meal on the 7th of August might not be at fault for the second episode. When he said that probably there was one infection, which necessarily has occurred before the 7th of August, the meal cannot be at fault. I'm not going to rehearse what we say in answer to issue 2. I'll leave you, if I may, to read that at page 88. In relation to issue 3, which is not explaining how it was that viruses were found in the samples and why they should be discounted, this provides a good example of what an issue that was not necessary for Professor Pennington to set out as part of his chain of reasoning. Because what he did do is identify that Giardia was the cause. He actually reflected on whether or not viruses were in play and explained that they weren't because A, there was no vomiting, see page 208. So that's under paragraph 4, like second and third line. And B, paragraph 3, page 207, if I'm not rushing. So para 3 at page 207, 4 lines up from the bottom, I consider it to be statistically improbable that he'd been infected simultaneously with Giardia, adenovirus, and rotavirus. So his chain of causation is made out. He'd identified and found that it was Giardia. The if you go back to what he's allegedly done wrong, failing, not explaining how it was that viruses were found in the samples, he has explained why they should be discounted, I've just taken you to that, but not explaining how it was that viruses were found in the samples, that is a classic example of the sort of question that could have been asked in cross-examination, and the quality of his answer may have led a judge to have confidence in his evidence overall, lack confidence in his evidence overall, or whatever. But it's not a necessary part of his chain of reasoning. It's a classic collateral question that can be asked in order to explore issues with an expert in the witness box in the way that happens.
Sorry.
Sorry.
Could I just ask you about paragraph 2? And we have the discharge report of the 16th of August, and that has rotavirus, adenovirus, and Giardia, etc. Antigen tests were positive. But then you have the witness statement of the doctor that says the rota, adeno, and norovirus tests were negative.
Yes, my lord.
Right. It is asserted that there were viruses in the stool sample, but that seems to be conflicting evidence.
My lord, yes, you're right. It's mixed evidence in relation to that plainly, again, we can see.
But Giardia, there's no mixed evidence about Giardia.
There's no mixed evidence about Giardia, and your lordship's right. It probably could go in as a third part or third limb to the analysis. It's certainly set out expressly the 2 points that I've taken your lordship to, and I think your lordship's right that one should also identify that the rota, adeno, and norovirus tests were negative. And again, exploring that is your classic question in cross-examination.
But the hospital doctor presumably can only have got the results from the discharge report itself. I mean, he didn't carry out any separate test.
Not to our knowledge.
No.
Not to our knowledge.
So if we have the discharge report, will that not be pretty conclusive?
My lord, there is one other part of the evidence that may throw some light on this at 1576, which is the witness statement of the appellant. You'll see at paragraph 62 that he says he was very concerned to be told that it showed multiple pathogens which were parasitic and viral, so that would tend to support the discharge report and the multiple positive samples.
Do we have the document, the discharge report
Yes,
itself?
Yes, we do, my lord. 1539.
Thank you very much.
I'm sorry.
Mr. Weir, can I just ask a general question at this point? As I understand your essential submissions, it's basically that the expert opinion had to have been accepted given that there was no cross-examination, unless it constituted something incredible or something without any rationale behind it, the ipsi dixit exception. Now, if that's the case, what is the role for the trial judge in that situation? Do you say the trial judge had no role to play once she had ruled out the incredible or ipsi dixit exception? Or is there still some role where she can look at the expert evidence and bring her own judgment to bear on it? Are you saying that is just precluded?
My lord, I'll just take that in stages, if I may. The stepwise approach that the court needs to take is, first of all, to recognise that the rule in Brown and Dunn is engaged. When it knows it's engaged, it knows as an issue of fairness that generally the report should be accepted. So that's where it starts.
Yeah.
And that if the report was, for instance, as we've discussed, on a very collateral issue that wasn't central to the case, or for whatever reason the expert couldn't possibly have ever answered the question, which is a little bit like saying they've made a mistake. There could be no answer to that. It's logically insupportable type scenario. Then the judge would say, well, it's not unfair in this scenario still to make my assessment. So I don't start from a sort of, unless it's A, B or C, no role. It's a very, it's not respectfully the appropriate language to employ when seeking to explain the function of the trial judge in this context. The function of the trial judge is making these assessments and determining whether, as a matter of fairness, as a consequence, the trial judge should accept the evidence or if you like, treat it as having been accepted by the opposing party. So the trial judge is not a rubber stamp, the trial judge is not denuded of responsibility, but the role of the trial judge is undoubtedly limited by the actions of the defendant in just the same way that I set it out by reference to Akhtar and Boland and the like at the beginning, that's what happens through the court process. A party says, I'm not going to call my own expert, which they had the right to do, to reduce their own expert evidence. That shapes the role of the trial judge.
But I still come back to the point that you are saying it was unfair here for the expert evidence not to have been cross-examined. Does it then automatically follow that the trial judge has no role? Once you've decided it's unfair, is that the end of it?
I'm only hesitating because the language no role is unattractive language. It's not a no role. The judge has a role, and the judge is playing her role by recognising that there's an issue of ensuring that there's a fair trial. That evidence should be accepted, or is deemed to be accepted. So it's not a no role. It's really not the right way of framing matters, in my respectful submission. It's a more active role than that. It's a role in which you can see from Chen and Ng what the court is doing is saying, where am I left in making my assessment as to how I can best ensure that there's a fair trial, having regard to fairness to the witness, fairness to the party and fairness to the court. How can I ensure that outcome is best achieved? And that is an active role for the court to play. And in circumstances where the court has given permission for expert evidence, it is a recognition, unlike I said sui generis, but per the judgment of my Lord Hodge in the recent Privy Council case, my Lord used language of special case for foreign cases, special rather than sui generis. So it's a special case where courts are so well placed with some law to make their own assessment. But otherwise, the court is not well placed. That is why it has given permission for an expert to give evidence on the issue. It is an issue meriting expert evidence. So there will still be those cases that are absurd or plainly wrong, and we haven't gone to the Essex and Woolley case, but that's where the expert made a mistake. The expert set out, these are the amounts that you can expect to earn in this job, and then in conclusion gave the wrong figure. Court of Appeal said, that's just the wrong figure. So sometimes the court can say, that's wrong. I mean, it's just, that was my example of 20-day incubation period. So the court is, even if the court is not saying it's wrong, it's actively not saying it's wrong. It's an alive court which is making these assessments, as opposed to the court saying, I wouldn't employ the language, the court is doing nothing. The court is debarred from. That's just not the right way to look at it. The court is ensuring a fair trial of the action.
And the consequence, if one were to decide that it was an unfair trial, is what?
The consequence is that the evidence must be taken to be accepted, or as put by Lord Horsbury, admitted. It's exact. I didn't take you through this part of our written case because I deemed it to be self-explanatory based upon where we got to through the cases. But if you go to page 75. Paragraphs 31 and following, the consequence of not following the general rule. That's, if you go to Chen and Ng, at paragraph 53, page 330. And I've read this passage out earlier.
So I think my question is, the trial may not be fair, but there is a leap then, is there not, to say that the evidence has to stand?
No, my lord, that's
you say the two are absolutely one and the same?
Well, if in order to...
As opposed to ordering a retrial, I suppose is what I'm saying.
Oh, no, it's not an issue of retrial. The last one is not having conclusions of litigation. This is important. This is a practical rule of real application in cases up and down the country, because many is the case. My learned friend prays in aid, which I'm going to come to in due course, lower value claims, and lower value claims have expert evidence from one party, as my Lord Briggs knows only too well, and we're not going to have retrials in those cases. Thank you.
Well, whether you have to have a retrial depends upon whether, if the unfairness perceived by the appeal court can be put right, you say in this case by accepting that part of the expert's report, that leads to a conclusion which doesn't require a further trial to get to.
Yes, well, I'm sure I can conceive or construct a notional case in which somehow, maybe it was like a huge piece of litigation, and the court overall says, with the multi-millions of pounds at stake, I just don't think, and it sends it off for retrial. But this would be highly unusual, and I'm here thinking of the ordinary case, of which this is a paradigm, a regular case going through the system. The rule is straightforward. I'm at page 330, para 53, where it's challenged. So this is the Privy Council, where it's not made clear during or before a trial in the evidence, or a significant aspect of the evidence of a witness is challenged as inaccurate. It is not appropriate, at least in the absence of further relevant facts, which may include the sort of proviso that my Lord Briggs had in mind, for the evidence then to be challenged in closing speeches or in subsequent judgments. So it can't be challenged, i.e. it's accepted. And that is exactly how Lord Halsbury had it, who was quite clear that the evidence, the language he used, and I think I've referred to this at page 308, near the top. If Mr. Willis admits before the jury, as I say, by the absence of cross-examination, he does admit that these statements are true, what is there for the jury? Does your Lordship see that? It's 308. And there's similar language, it's not quite in those terms, from, or certainly the effect of the speech of Lord Herschel. I'm trying to find it, in which effectively the plaintiff is disentitled from pursuing its allegation that the defendant's solicitor had made up his evidence. It was a sham.
Yes, one can see the thinking there, because in relation at least to factual evidence, if certain facts are alleged and nothing is done to rebut them,
yes, my Lord.
At one level you can just say, well, the facts are proved. At another level you can say, well, adverse inferences will be taken against the defendants. They could have come in and said something, they've chosen not to. Similarly with expert evidence, an expert has said this, he hasn't been cross-examined, there's no alternative expert explanation. You say the consequence there is the court treats the expert's evidence as established.
That's exactly the point, my Lord. It's page 208, last sentence. This is the I started with this right at the beginning of my submission, and I didn't take you to the document. But this is it. He says, on the balance of probabilities, Peter Griffiths acquired his gastric illnesses following the consumption of contaminated food or fluid from the hotel. That establishes causation. The defendant has elected not to cross-examine that expert on that opinion evidence, and it is taken as accepted. You can say admitted by the defendant, accepted by the defendant, or it stands and the court accepts it. It all comes to the same thing, my Lord, but are absolutely the same in answer to the question from my Lord Paris. Very much the same point. Mm-hmm. But it is an active process. It's an active process of making that assessment as to how to achieve a fair outcome at the trial, as opposed to a negative process of saying I am excluded from. Because not only is that unattractive, it's not how the judicial function works in this context. I was back on our written case and going through our list at page 88, and the next one was number 4, which said failing to address why non-food related methods of transmission should be discounted. By stating his opinion as to the cause of the illness, Professor Pennington was in the same breath rejecting other causes. And that's the submission I've made already in response to the observations of my Lord Briggs. It's a necessary corollary of the opinion he's adopted. And so we say respectfully that the trial judge was quite wrong. Page 181, paragraph 28. Last sentence. When she says, where the report does not mention a number of the raised other possible causes, I do not think it would be appropriate, without more, to assume those other causes have been considered and discounted for some good but unspecified reason. The correct approach, we say, is set out by Mr. Justice Martin Spencer at paragraph 36, but you can go here to the judgment of Lord Justice Bean, please, because he quotes from this approvingly, and it's page 138, paragraph 88. And if you kindly read the indent, which is the quote from Mr. Justice Martin Spencer, and then as you go down it, so he says, it may be that had the defendant served controverting evidence, Professor Pennington would have expanded upon his reasoning, for example, in a meeting of experts, and such reasoning would have found its way into a joint statement. As it turns out, that step never became necessary because the evidence of Professor Pennington stood alone. Nor did the defendant seek to challenge the reasoning that might have lain behind his conclusions by calling him to be cross-examined, as it had every right to do. In those circumstances, the court must assume that there is some reasoning which lies behind a conclusion which has been reached and summarised, and that this reasoning is not challenged. And that is of a piece with a dictum from Lord Justice Ralph Gibson in the associated shipping case, if you will kindly go to page 294. And it's in the middle, the paragraph in the middle that starts, it might be that a system of law. And then picking it up in the next sentence, Mr. Manfield, however, gives no such explanation of his reasoning. He relies for his conclusion simply upon the facts of the appointment of the two chairmen and upon the evidence of Mr. Manny. The matters stated do not, in my judgment, support a conclusion according to any stated process of reasoning or any process of reasoning which I find to be implied in his evidence. In other words, the court has to recognise this is an expert who has signed a statement of truth, saying, this is my opinion. And as with any report, unless this court really wishes to invite prolixity in reports, there are going to be some reasons that are expressed and some that are implied. They're inherent, they're part of the expert knowledge. It's a little bit like asking this court to write out a little exposition on a certain area of law. And I could probably always say, well, hold on, what do you mean when you say tort law? Before you get on to immediately talk details about the law of negligence. Because depending on where my starting position is, I can always ask further questions and always say, you haven't explained that to me. And they may not be good examples, but Your Lordship, I think, can see the point. So there will always be parts of the reasoning that the expert has taken as read or simply hasn't set out. And if you choose not to challenge by the mechanism set up by our adversarial system for challenging, namely cross-examination at trial, then you must be taken to have understood and recognised that there is a stated and implied reasoning to that report. And that's why you then go to the really extreme case when you just say, I'm sorry, but this is literally logically insupportable. The incredible scenario. Incredible for us captures those series of words, absurd, incredible, etc., all different, but it's the target is clear. And then if I go back again to that same page, which I think is 88, please, our written case, failing to provide a range of opinion. Well, Professor Pennington acknowledged it was possible that the appellant had suffered 2 infections. And that, respectfully, I would say, is a recognition of a range of opinion, in just the same way as he recognised the possibility there was a viral cause but favoured Giardia for the reasons which I've already given. That is a different way of expressing a range of opinions, which anyway see Lord Justice Bean at paragraph 97 that we've referred to in our written case is not fatal. Maybe an oddity, but Part 35 does not set out in terms what may seem obvious, not least in light of Kennedy and Cordia, namely it does not set out anywhere as such you need to provide reasons for opinion. I'm not saying don't provide reasons for opinion, I'm just saying it only actually says it in relation to where there's a range of opinion. And then the final submission I wish to make is in response to the respondents' arguments in relation to what they describe as unfortunate practical and consequences of adopting the appellant's case. And as a precursor to these submissions, we would say that our primary case is this appeal should be decided on the basis of the legal principles on which we've made submissions, not on the basis of soft, unevidenced factors as to the stated consequences of what is otherwise assessed by the court as the correct course of action to take. It is a hazardous journey for the court in any circumstance. In any event, civil litigation encourages certainty and settlement. And where one party has a report which the other side does not challenge, those aims are achieved by respecting the rule in Brown and Dunn, and not by permitting one party to ambush the other at trial, making criticisms of the other side's written expert evidence without paying the price of cross-examination. Litigation functions well where if one party has an expert report with a clear conclusion and the other party does not adduce contrary factual evidence or contrary expert evidence and elects not to cross-examine the expert, then it should be expected that the party's expert evidence is accepted by the other side. Take the small cases in, for instance, personal injury litigation. Exactly what you would want to happen in order to encourage certainty and settlement. So if the claimant adduces a shorthand whiplash expert report and the defendant either the rules don't encourage or isn't allowed or chooses not to, as in this case, in the multi-track case where they had permission to adduce their own contrary expert evidence, doesn't seek to challenge that expert's evidence by cross-examination, doesn't seek or succeed in obtaining contrary factual evidence to undermine the whole premise of the claimant's case, then that's exactly what you would want to happen. Namely, well, that part of the evidence then has to be accepted, because that's the key evidence on causation for the small whiplash claim, because that will deal with causation and prognosis. And under the new fixed tariff scheme, the joys of which this court has now given permission to analyse in due course, no doubt next year, that's how it functions, because there's one medical report and the tariff award is given based upon the medical report and its prognosis. How long will this whiplash last for? Gives an answer, not an answer to be fought over. So it's quite the opposite way round. This is a very fair system, providing, subject to proportionality, because with the lower value the claim, the less likely you are to have permission to take active and expensive steps. But in a case like this, which was multi-track, where the defendant was given the opportunity to take active steps by way of expert evidence and cross-examination, if the party chooses not to take those steps, this is the consequence. That's completely fair. That's the parties controlling the litigation, the opening submission I sought to make. My Lords, unless I can assist further, that is the appellant's case.
Thank you very much, Mr. Wynne. Mr. Stevens.
My Lords, the central issue in this appeal is whether the fact that Professor Pennington's evidence was uncontroverted disentitled the judge from assessing that evidence in the way she did and concluding that the appellant had not proved his case. Now, the appellant's argument is that uncontroverted evidence, according to the definition he gives to uncontroverted, cannot, save exceptionally, be rejected or not accepted in proof of a claim, as I might put it. I respectfully submit that that involves two things. First, an unwarranted extension of the rule, or so-called rule, in Brown and Dunn. And secondly, a consequential, impermissible erosion of the judicial function. I submit with respect that Lady Justice Asplin was right when she held at paragraph 65 of her judgment at 133. I summarise that the court cannot be prevented from considering the quality of expert evidence in order to determine whether the burden of proof is satisfied simply because the expert evidence is uncontroverted. And the reason for that was articulated by Lord Justice Nugee in paragraph 81 of the judgment at 136, where he said this: as a matter of basic principle, it is the function of trial judges to evaluate all the evidence before them in reaching their conclusions on factual issues. That includes deciding what weight should be given to the evidence. I see nothing in the authorities that suggests that the obligation to assess the evidence falls away if it is uncontroverted. Uncontroverted evidence still has to be assessed to see what assistance can be derived from it, viewed in the context of the circumstances of the case as a whole. Uncontroverted evidence may be compelling, but it may not be. It may be inherently weak or unhelpful or of little weight for other reasons. In other words, that essential function of the court was recognised in the context of expert evidence in a Scottish case called Davy and the Magistrates of Edinburgh, which was cited with approval, albeit for a different reason, in Kennedy. That is at 358 of the authorities. And let me accept immediately that there was other evidence besides the expert evidence that was challenged, and that there was cross-examination in this case. Can I take you first to page 359, where there's a summary set out before we get to the Lord Ordinary's opinion, which was appealed. So at 359, you'll see that the pursuer led evidence from 14 witnesses, including a builder, an architect, and a civil engineer, to the general effect that during the substantial period when the tunnelling operations were taking place, explosions were heard regularly, vibration was felt in the pursuers and other adjacent houses, articles in their houses were disturbed, that as the blasting proceeded, various cracks became evident in the pursuer's house and numerous other houses. And then just dropping a couple of lines, the pursuer led no expert scientific evidence as to the effect of the use of blasting explosives on nearby buildings. The defendants, on the other hand, did. So the defenders adduced, among other witnesses, Mr. Shannon, a civil engineer, and he gave evidence in respect of blasting. But then, and for present purposes more importantly, in the next paragraph, the defenders also led evidence of Gordon Teichmann, a mining engineer and advisor on blasting who'd made a special study of the effect of blasting vibrations. And he gave some scientific evidence relating to the amplitude of ground movement and so on. And then, dropping 4 more lines, he further gave evidence that the amplitude of movement permissible with safety in the case of blasting in the vicinity of houses was much greater than that which could be caused by the weight of explosives used by the defenders' contractors, and that a far greater weight of explosives could have been exploded at one time without damaging the pursuers' houses. We then go to Lord Strachan, the Lord Ordinary's opinion, and if I could ask you to turn to page 361. In the second paragraph, he says, "If I'd had to dispose of the case upon the evidence to which I have already referred and without the expert evidence on explosives, I would have found without much difficulty that the damage to the pursuer's house was caused by the blasting. The evidence of the expert, however, is of crucial importance. And if I accept it in toto, it would force me to reach the opposite conclusion." Dropping to the middle of the page, he refers to Mr. Teichmann. He says, "Mr. Teichmann's evidence is to the effect that it was not possible for the pursuer's house to be damaged by the blasting in the sewer. His qualifications are beyond question. Great respect must be paid to his views." Dropping another 4 lines, "No contrary evidence from an expert on explosives has been put before me, and in that sense, Mr. Teichmann's evidence is unchallenged. Nonetheless, I have to consider whether his conclusions on the facts of the present case are justified by his evidence taken as a whole." He then considered Mr. Teichmann's evidence and expressed his opinion that Mr. Teichmann has not succeeded in putting his conclusions entirely beyond doubt. Mr. Teichmann's evidence is not sufficient to displace what, in my opinion, is the result of the other evidence in the case. The defenders reclaimed, and we see the judgment of the Lord President, Lord Cooper, starting at 362. Dropping to the 4th line, Lord Cooper said, "It is accepted that the defender's liability depends wholly upon the answer to the question whether it's been sufficiently proved that the damage to the pursuer's house was attributable to the blasting conducted by the defender's contractors." Turning the page, "The single issue is thus one of causation, and this is an issue of pure fact for determination by the court, aided by expert opinion evidence on the technical and scientific aspects of the case." He then, for his part, I won't read it all, refers to the different types of evidence in a paragraph just above the middle of that page, starting on the major issue of liability. The evidence falls into 3 chapters. He says chapters 1 and 2 occupied much the greater part of the proof and included the evidence of some 19 witnesses. And then, if there was nothing more in the case than this, it would be quite possible for us to overturn the judgment of the Lord Ordinary, who accepted this evidence, for the inference as to causation is well nigh irresistible. In the next paragraph, "The only difficulty experienced by the Lord Ordinary and developed before us arose from the scientific evidence regarding explosives and their effect." And dropping to the bottom of that page, the last 3 lines, "The true question is whether the Lord Ordinary was entitled to discard Mr. Teichmann's testimony and to base his judgment upon the other evidence in the case." And then on 364, this, "Founding upon the fact that no counter-evidence on the science of explosives and their effects was adduced for the pursuer, the defendants went so far as to maintain that we were bound to accept the conclusions of Mr. Teichmann. That view I must firmly reject as contrary to the principles in accordance with which expert evidence is admitted. Expert witnesses, however skilled or eminent, can give no more than evidence. They cannot usurp the functions of the jury or judge sitting as a jury, any more than a technical assessor. Their duty is to furnish the judge or jury with the necessary scientific criteria for testing the accuracy of their conclusions so as to enable the judge or jury to form their own independent judgment by the application of these criteria to the facts proved in evidence. Scientific opinion evidence, if intelligible, convincing, and tested, becomes a factor, and often an important factor, for consideration along with the whole of the other evidence in the case, but the decision is for the judge or jury." He then says, in particular, "The bare ipse dixit of a scientist, however eminent upon the issue in controversy, will normally carry little weight, for it cannot be tested by cross-examination or independently appraised, and the parties have invoked the decision of a judicial tribunal and not an oracular pronouncement by an expert. And then after the reference to best on evidence, that the Lord Ordinary was entitled to discard the evidence of Mr. Teichmann, I do not doubt. It remains to consider whether he was right, and then he went on to deal with that. There's just a very short paragraph from the opinion of Lord Russell, which starts at 365, and the paragraph that I invite you to look at is on 366. About 10 lines down, in the middle of the line, the opinion expressed by an expert witness in any branch of technical science depends for its effect on inter alia his qualification, skill and experience in that science. If it appears to be based on a sufficiency of research directed accurately and relevantly to a particular issue, and to be so supported as to convince the court of its fundamental soundness and applicability to the particular issue, a court is entitled, although not obliged, to accept it, even if unsupported by any corroborative expert opinion. Secondly, the defenders argued that in the evident absence of any counter-evidence of expert opinion in the science professed by Mr. Teichmann, the court is bound to take his opinion as conclusive and as decisive of the issues. I am clearly of the opinion that argument must be rejected as contrary to the principles by which the rules of evidence are regulated and as constituting an unwarrantable encroachment on the judicial function of the court. My Lords, I hope you'll forgive me for having taken you to that, the length at which I have. I'm concerned in this part of my submissions with, respectively, the role of an expert and the essential function of the court.
In that case, there was a challenge during cross-examination of Mr. Teichmann's evidence. And there was substantial evidence from a whole series of people that they had houses perfectly okay before the blasting took place and were damaged afterwards.
My Lord, I hope I accepted that at the very outset.
You did.
The only point I'm seeking to take from this authority is in relation to the essential function of the court when assessing evidence, and in particular expert evidence.
But the point that I was seeking to establish was the essential function of a court when the evidence is challenged.
Well, my Lord, in that respect, I respectfully submit that the observations of Lord President and Lord Russell are of general application, whether or not the evidence is relied upon, which is relied upon, is controverted.
Well, that may not be so, but you don't get anything from this case that supports that submission, do you?
Well, my Lord,
he's talking about it. He's giving judgment after a trial, which everyone's been through. There were 14 factual witnesses supporting the claimant's case.
There were, my Lord, but my Lord, I've only, with greatest respect, only taken your lordships to it because the starkness of the proposition does reduce to what my Lord Burrows was putting to my learned friend, namely that in the event that it is controverted, unless you can rule it out on grounds that it is incredible, effectively the role of the court falls away. And it's merely to make good the proposition that, maybe an obvious one, that the court nevertheless has the job of judging. The expert's evidence is opinion evidence. The expert is not the decision maker, and there is a real risk in what the learned friend is submitting in effectively bypassing that process and delegating the decision making to the expert in circumstances where it may not be possible to say that the evidence is so incredible that it should be rejected, but in which, on a proper analysis by a judge, it is lacking in the sense that it doesn't prove what is required to be proved.
Well, couldn't the real risk be avoided by simply cross-examining?
Oh, my Lord, that is of course what often happens, and it might even be said that that's what any sensible defendant should have done in this case. But that's not to say that if the defendant takes the decision it took in this case, that the function of the court is any different. It nevertheless remains the function of the court to consider the evidence before it. It might have been a high-risk tactic, as I think it's been suggested by one of the judges. But nevertheless, if the defendant does not cross-examine, the court still has to decide the case on the basis of the evidence before it.
Well, to the extent that that's consistent with a fair trial. I don't suppose anybody here would deny that the basic function of a judge is to decide cases on all the evidence that's put before them. No. But where some evidence isn't controverted,
well,
why is it, and could be controverted, and where a cross-examination might produce answers that fill the supposed gaps in the reasoning, but why is it fair to apply a full critical assessment of the evidence when it hasn't been controverted?
Well, my Lord, the question is...
In the absence of any ability of the expert to explain, to deal with the criticisms.
Well, my Lord, the question is whether it was unfair. Now, I'll come in due course to address that, particularly in the light of what I say one gets from the rule in Brown and Dunn. But ultimately, one starts from the proposition which equally is going to be widely accepted, that it's for the claimant to prove their case. And the claimant decides what evidence to put before the court. Fairness does not extend to requiring a defendant to cross-examine the claimant's expert or any other witness if the evidence that's put before the court does not satisfy the burden of proof. And in this case, for reasons I'll come to in my respectful submission, the evidence did not satisfy the burden of proof, and there's nothing unfair in that situation. What my learned friend is contending for is an opportunity to improve evidence which, if I'm right, was so lacking it did not discharge the burden of proof. And that's very different to it having been an unfair trial. My Lords, I've submitted... I'm sorry. Submitted a moment ago that the observations of the Lord President and Lord Russell are of general application regardless of whether the evidence is controverted. That in my submission is true both as a matter of principle, but also to some extent from the judgments themselves, bearing in mind and notwithstanding the cross-examination and other evidence there was, that the Lord President and Lord Russell's remarks were made in the context of a submission that the evidence should be accepted because there was no contrary explosives evidence. So they were very much considering a situation in which a particular piece of the evidence was not controverted by other evidence, albeit I accept there was cross-examination, although we don't know the extent of that cross-examination. There is no suggestion that the entitlement of the Lord Ordinary to discard the expert evidence, which was affirmed on appeal, turned either on the fact that the expert was cross-examined or that there was other evidence. There's no express suggestion to that effect. Rather, what is clear is that the evidence was considered on the basis of its merits. And more fundamentally, in my respectful submission, as a matter of principle, clearly the role and functions, respectively, of an expert on the one hand and the court on the other, should not and cannot be affected by the absence of contrary evidence or cross-examination. If the expert evidence in question is not intelligible or convincing, those were the words the Lord President used, it may therefore, in my submission, be rejected, or at any rate, in the present case, not accepted in proof of the issue in question. And in particular, the absence of cross-examination cannot, in our submission, render what is a decision for the court, not the expert, no longer a decision for the court. The court is bound to evaluate the evidence. Now, my Lord Briggs asked a question which at some point I'm going to have to answer of Mr. Weir. My Lord asked him, how can you say that the judge did not decide the expert was wrong or did not reject the evidence given the finding? Well, my Lord, that is with respect an important question, but it admits of a very straightforward answer which has to do with the burden of proof. The judge in this case did not decide that the expert was wrong because she did not decide that it was not food which caused his illness. What she found was that the evidence was insufficient, and therefore she was not satisfied that the burden of proof had been satisfied, and the case advanced at trial, although it was a much wider case in the pleadings, had therefore not been proved. And, my Lord, it's important to bear in mind that in this case there was not contrary evidence adduced by the defendant to the effect that it wasn't that, it was the swimming pool, or it was something else, a contaminated surface which you touched from which you picked it up, or person-to-person contamination, and we'll look later at some of the other competing candidates. It was not a case where the defendant did that. The defendant simply put the claimant, the appellant, to proof. Had it been that sort of case, then the judge would have had to weigh the competing evidence and decide positively, or at least done her very best to, which it was. That might have involved either accepting or positively rejecting Professor Pennington's evidence. But where, as in this case, a party is merely put to proof and the defendant raises as possibilities without advancing a positive case that it was X, Y, or Z, that it could have been X, Y, or Z, then it's permissible, and it's exactly the sort of case where a judge may have to resort to the burden of proof. And that is why the judge found the case was not proved, and that analysis was accepted by the majority in the Court of Appeal, but not by Lord Justice Bean. Because
I struggle to get a sheet of paper between the failure to between, on the one hand, saying the expert was wrong in expressing the view that the most likely, that the more likely than not cause was the ingestion of food or drink at the hotel, on the one hand, and the conclusion of the court that the burden of proof hadn't been discharged. I mean,
well, that was
where's the difference?
That was the expert's conclusion.
Yes.
What the judge was saying is you might be right, you might not be right. But looking at your report as a whole and the reasoning and the paucity, I'm afraid, of that reasoning which preceded the conclusion, I cannot be satisfied by the conclusion. I cannot, therefore, be satisfied that it was food.
But that's the burden of proof. In a sense, you come to a decision as to whether he was right or not right.
No. You come to a decision that the claimant has not proved his case.
No. You come to that decision, but in order to come to that decision, you have to say that the expert was wrong to say that it was more likely than not that the food and drink was the ingested in the hotel was the cause of the disease.
Respectfully, no, my lord, because a party can adduce a certain amount of evidence in a case with a view to proving something, but not adduce sufficient evidence in order to prove that.
But still, that would make the conclusion wrong, wouldn't it?
No, not necessarily.
But here you have an expert. You have an appropriately qualified expert who has addressed absolutely indirectly the issue which he's been asked to address, namely, was the illness caused by the ingestion of food at the hotel? And he says, in my opinion, on the balance of probabilities, which is no more than expressing the same standard of proof as the judge has to apply, it was. Now, unless it's just a mere ipsy-dixit and therefore weightless, because it's wholly unreasoned, why, in a case where it's not challenged, does that not satisfy the burden of proof?
Because, my lord,
what mysterious added additional quality requirement is needed?
Well, my lord, I'm going to have to come to it in some detail, but
yes.
The case was put on a much broader basis than just food. And the expert himself recognised when reciting the terms of his instruction that he had been asked to provide a detailed commentary on the issue of gastric illness and any breaches in the health and safety procedures in place at the hotel. Now, there were multiple allegations going to potential causes other than food. And we'll see in due course that the defence likewise put in issue other possible causes. We'll see that the Part 35 questions touched on that. We'll see that he, Professor Pennington, endorsed as reliable sources government papers which made clear that there were many ways, I paraphrase, but it's virtually that, in which you can contract giardia, assuming it was giardia.
Why don't you get up and at him?
I'm sorry, my Lord?
Why don't you cross-examine him about all these other potential things and expose, for the benefit of the judge who has to decide the issue, exactly what the issues are?
Well, the judge has to decide whether or not the claimant's proved his case, and when it came to the trial, the claimant advanced his case solely on the basis that it was food. Now, the only question from the judge was whether or not that case was made out. The defendant could have cross-examined, but was not obliged to cross-examine. It was permissible to say the proof, the evidence adduced to persuade you of that is not sufficient. And that, in effect, is what the defendant did and what the judge accepted. And we'll come to it, but we'll see that even Mr. Justice Martin Spencer found that there were serious deficiencies in the report. Both
Speaking for
judges.
myself, the concept of being able to challenge now on the basis of cases that could have been made at trial doesn't really strike me as being particularly fair.
Well, my Lord, we're going to have to go into greater detail at all of this, but I mean, my route map in relation to fairness is going to be that there was wooden TUI, which is instructive. There was the way the case was put by the claimant himself. There was the way the case was defended. There were Part 35 questions and answers. Those included an answer which admitted of other possible causes. That was the professor's own evidence. And then there is a report that recites the breadth of his instructions, conspicuously fails to deal with pleaded issues, despite saying that he'd had the particulars of claim, and so on and so forth, concludes in very short form that the illnesses, plural, about which I'll have to say something as well, were caused by the ingestion of contaminated food, in a way that, with respect, was lacking in reasoning and omitted various steps in the argument, if indeed it was the conclusion to which he was able to reason. And there's nothing, in my respectful submission, unfair in circumstances where the claimant himself has opened the door to various possible causes, and all of that has happened in submitting that ultimately he hasn't proved his case based on this report. I entirely accept the defendant could, and indeed, given that we're all here now, might have been well advised to cross-examine. But that's not determinative with respect of the issue. Now, my Lord, perhaps I'm sorry, I've been slightly diverted.
I think we should allow you to develop your submission. Thank you.
Well, no, I've no problem with being diverted, but I'm concerned that there's obviously quite a lot to get through, my Lord.
Yes.
So, just returning to the submission I was on, which was focusing on the essential function, as I described it, of the court. Can I now ask you to have a look at a case which you've already been shown, which is the Associated Shipping and Department of Private Affairs case, which is at 286. Because although you've been taken to a good deal of it, you've not been taken with respect to all of it, and this part I'd like to show you. But before I do that, just to put this in context, Mr. Baldo intervened in the proceedings in order to apply for an order that the action be dismissed on the ground that the named defendant, the Department of Private Affairs, did not exist as a juridical entity, and he gave evidence by affidavit as to the status of the defendant. For its part, the plaintiffs relied on an affidavit from Mr. Manfield, who you have heard mention of, who was an English solicitor licensed to practice in the UAE, and whose qualification by both knowledge and experience to give expert evidence was not in dispute. The plaintiffs did, however, dispute Mr. Baldo's entitlement to give evidence as to Abu Dhabi law, and submitted that since the only admissible evidence as to the status of the named defendant was the uncontradicted evidence of their expert, Mr. Manfield, it was not open to the court to reject his, Mr. Manfield's, evidence. Now, as it turned out, both the judge and Lord Justice Ralph Gibson considered that Mr. Baldo was competent to give expert evidence on the point of law in question. So what Lord Justice Ralph Gibson had to say, and to which I'm coming, was therefore strictly obiter. You've been shown the passage at the top of 290, where he said, for my part, I would dismiss this appeal for the reasons which follow. It would be a sufficient ground, I think, to hold, as I do, that the plaintiffs have failed to prove by the evidence of Mr. Manfield that the DPA exists as an independent legal entity. But then he goes on to make the points about Mr. Baldo, consider the evidence of Mr. Baldo, and ultimately conclude over the course of a few pages that he too was competent. Now, if you could go to page 293, but I should make the point, lest it's not already been clear, that this was not a case where there was any cross-examination. The second substantial paragraph on the page. In the end, therefore, I reject Mr. Lippman's submission that the only admissible evidence as to the status in law of the DPA was that contained in the affidavit of Mr. Manfield, and it is accordingly not necessary to consider the authorities cited by Mr. Lippman in support of the proposition that the court may not reject the uncontradicted evidence of a qualified expert on an issue of foreign law.
So where are you reading from? I'm so sorry.
The middle of page 293, my lord. It's the third paragraph, the second main paragraph on the page.
Thank you, thank you.
Would you like me to start again, my lord?
No, don't reread it. I just wanted to find the spot. Thank you.
Qualified expert on the issue of foreign law, merely because the court, upon the material produced by the expert, would have taken a different view of its effect, but must accept that evidence unless satisfied that it is impossible, as directly contrary to the words of the statute, or at least extravagant, and contrary to the principles which lawyers in any system of law would recognise. And then there was reference to several authorities, of which one was A.S. Talina. It is useful, however, to cite one passage from the judgment of Lord Scott in A.S. Talina, and that's the passage you've been taken to. For my part, I am not persuaded that even if there had been no admissible evidence on the issue other than the affidavit of Mr. Manfield, the court would have been compelled to accept and not act upon his evidence, having regard to the unconvincing reasoning upon which, for the reasons given below, his opinion appears to me to have been based. So this I accept in the context of evidence, expert evidence of foreign law, about which I'll say something in a moment, is a case in which obiter, because ultimately he didn't need to decide the case on that basis, Lord Justice Ralph Gibson found quite clearly that he was able to discard or put to one side Mr. Manfield's evidence, notwithstanding that it wasn't contradicted. And on the opposite page at 294, to which some of which you've been taken, we see in the second, third, and fourth paragraphs his reasons why he would have rejected it. He, in the first of the paragraphs, about 4 lines down, I find it difficult to understand what relevant force or content can be given to that assertion. DPA plainly consists of persons and equipment separate from the ruler himself, whatever the nature and law of the DPA, and so on. Then in the next paragraph, which I think you were taken to, but just if I may, noting at the third from last line, it does not, in my view, provide any basis for any reasoned conclusions. And then in the final paragraph, to which you were also taken, Mr. Manfield, I'm in the second line, however, gives no such explanation of his reasoning. He relies for his conclusion simply upon the facts of the appointment of the 2 chairmen, upon the evidence of Mr. Manny. The matters stated do not, in my judgment, support the conclusion according to any stated process of reasoning or to any process of reasoning which I find to be implied in his evidence. So acknowledging that one might be able to imply reasoning as Mr. Weir's urged upon you in relation to some of some of the gaps that have been identified in Professor Pennington's evidence. Mr. Littman argued that in the absence of cross-examination, such a conclusion is not open to the court. I do not accept that submission. The court is entitled, and I think obliged, to use its own intelligence in assessing the evidence of an expert on foreign law, and there's the reference to A.S. Talina. Now,
just if I can understand that this was an application to strike out the plaintiff's statement of claim.
On the basis that the defendant didn't exist as a juridical entity, yes.
And it was, everyone was proceeding on the basis of affidavit evidence on that issue.
I accept that entirely, my lord. But the fact that it wasn't a trial doesn't, with respect, detract from the principle that the court was able to decide finally the issue between the parties on the basis of the uncontradicted affidavit evidence by recourse to an evaluation of the quality of that evidence.
But it was contradictory, wasn't it? Because there was evidence from Mr. Baldo to the opposite effect, which directly contradicted Mr.
Sorry, my lord, I did say that at the outset I said that, but I also said it was strictly obiter because, having found that Mr. Baldo was expert and therefore there was contradictory evidence, the court did not need to decide it on this basis. But what Lord Justice Ralph Gibson made absolutely clear at 293 was that even if there had been no admissible evidence and so on, and then at 294, the bit I've just read, the court is entitled, and I think obliged, to use its own intelligence, etc. So what he was saying was, had I not had Mr. Baldo's evidence, I would have reached the same conclusion based on my assessment of the quality of Mr. Manfield's evidence.
Well, certainly my experience is on interlocutory proceedings on affidavit, where you have a conflict of evidence. Well, sometimes you just got to resolve the conflict of evidence on the basis of the affidavits, but I would usually give the parties an opportunity to make an application to call the witnesses if there was a real conflict. And I don't know what the background to this case was.
And my lord, one knows of different situations, different interlocutory situations in which it's either more or less common to have cross-examination. I mean, family proceedings are a particular example where it's rare to have cross-examination.
This case appears, from what you've read from Mr. Justice Ralph Gibson's judgment, to have satisfied Mr. Weir's sort of reverse summary judgment test.
Well, I wouldn't have.
If it was a strikeout and succeeded, it was on the basis that the judge looked at the only two reasons given by the expert, considered that they didn't go anywhere to support his opinion, so that it was one of those cases where the opinion was simply, if you like, wholly unsupported by any reasoning.
Well, my lord, I accept it was in the interlocutory context, and I accept that he didn't find the reasoning sufficient, but it was very much expressed in terms that it was insufficient, not that it was hopeless or incredible or manifestly incredible.
Well,
I'm sorry.
Well, not far off.
But also, my lord, there's a further point. This is all in the context of the consideration of foreign law as a question of fact.
Well, I said
and there is at least the board has held, obviously that's not binding on the Supreme Court, the board has held that there's a spectrum of cases, and in some cases a judge will have to bring to bear his or her own legal reasoning in testing an expert's assessment of foreign law.
Well, my lord, yes, and I'll deal with that more fully in a moment, but my short answer to that would be that if the law concerned was very alien to the tribunal engaged in the exercise, the court would be in no different position considering expert evidence of foreign law than it would be in considering scientific evidence.
Yes, the law of the UAE, I imagine, on this point would be alien to English law.
Well, I think with respect it would. My Lord Briggs has sought to draw an analogy between the exceptional case and the test for that propounded by Mr. Weir and the reasoning of Lord Justice Ralph Gibson. I've made the point that I don't, with respect, accept that it really is tantamount to going that far, but I will, in due course, my Lord, come to the test, because I don't accept that test. Can I deal with that when I get to Brown and Dunn, please? To deal now with the point my Lord Hodge just put to me about the potentially sui generis nature of expert evidence of foreign law, make three submissions. First, the appellant's argument proceeds on the basis that the rule in Brown and Dunn applies equally to expert evidence as it does to factual evidence. And if its scope is as wide as the appellant suggests, there is, in my submission, no principled reason why it should not apply to expert evidence of foreign law. Secondly, and more importantly, and it's a point I just touched on, the court will not always be particularly well placed, as my learned friend puts it in his written case, to assess expert evidence of foreign law. It may be, if the relevant law is the common law, or some equivalent common law as we know it, and at any rate similar to that in England and Wales, it may be, the court may be better placed. But there will be as many or more examples of instances where the foreign law in question is alien to a tribunal in England or Wales, as there will be instances where it feels comfortable dealing with it. Thirdly, and fundamentally in my submission, foreign law evidence is still evidence, and as such requires to be evaluated in the same way as other evidence. The appellant's argument is that uncontroverted evidence cannot, save exceptionally, be rejected. Now, as a matter of principle, if that's correct, it must apply generally and cannot depend upon whether or not the court is well placed or not to evaluate the expert evidence in question. So, my Lord, those are my slightly more detailed submissions in relation to the distinction which is sought to be drawn between the category of evidence in this case and, on the other hand, expert evidence as to foreign law. Now, my Lords, it is precisely because the court is required, as I've submitted, to evaluate all evidence, but expert evidence in the present context, whether or not it's controverted, that it's essential that an expert provides his or her reasoning. And we looked at Davey a moment ago, and what the Lord President said at 364 about the expert's duty, the duty being to furnish the judge or jury with the necessary scientific criteria for testing the accuracy of their conclusions so as to enable the judge or jury to form their own independent judgment by the application of these criteria to the facts proved in evidence. But it's very important to bear in mind that it is no more than evidence. It's evidence of opinion, which by reason of experience and or qualification the witness is entitled to give, but it's still evidence. And the judicial function is still to evaluate it and bring its own independent judgment to bear. And in that regard, Davey was cited with approval by the Lord President, Lord Roger, as he then was, in the case of Dingley and the Chief Constable of Strathclyde Police, another Scottish case, at 368. And I won't read it to you because it is simply an endorsement of the passage I read to you from Davey. It's at 375. But what I would do, if I may, is take you to another passage in the Dingley judgment, in the judgment not of Lord Roger but of Lord Prosser, at page 424, between letters C and E. I would wish to make two other general observations before turning to the issues between the parties. First, there was a certain amount of evidence to the effect that certain views on causation were very widely held or no longer widely held. If a particular process of reasoning is widely accepted, then I think that may be persuasive for a court. But the fact that a particular view is widely held without any persuasive explanation as to why it should be so held and constitute a conclusion does not appear to me to be a matter to which a court should give sufficient weight. Rather, Rather similarly, the fact that a particular view was or is held by someone of great distinction, whether he is a witness or not, does not seem to me to give any particular weight to his view if the reasons for his coming to that view are unexplained or unconvincing. As with judicial or other opinions, what carries weight is the reasoning, not the conclusions. Now, I'll have something to say about unexplained and unconvincing in the context of Professor Pennington's evidence with respect to him in due course. Davey and Dingley were both, of course, cited with approval more recently in Kennedy and Cordia. And although there's been a good deal of reference to it, I'm not sure that you've actually been taken to it. It's at 476. And if I could take you to the judgment of Lord Reed and my Lord Hodge, with whom the other members of the court agreed, at 491, please. Paragraph 48, an expert must explain the basis of his or her evidence when it's not personal observation or sensation. Mere assertion or bare ipse dixit carries little weight, as the Lord President Cooper famously stated in Davey and Magistrates of Edinburgh. If anything, the suggestion that an unsubstantiated ipse dixit carries little weight is understated. In our view, such evidence is worthless. Wessels J.A. stated the matter well in the Supreme Court of South Africa. Reading from that, an expert's opinion represents his reasoned conclusion based on certain facts or data which are either common cause or established by his own evidence or that of some other competent witness, except possibly where it's not controverted. An expert's bald statement of his opinion is not of any real assistance. Proper evaluation of the opinion can only be undertaken if the process of reasoning which led to the conclusion, including the premises from which the reasoning proceeds, are disclosed by the expert. As Lord Prosser pithily stated in Dingley, as with judicial or other opinions, what carries weight is the reasoning, not the conclusion. In the Davey case, the Lord President observed that expert witnesses cannot usurp the function of the jury or the judge sitting as a jury. And then there's reference to Pora, where it was said that it's the duty of an expert witness to provide material on which a court can form its conclusions on relevant issues. And then just below that, thus, while on occasion, in order to avoid elusive language, the skilled witness may have to express his or her views in a way that addresses the ultimate issue before the court, expert assistance does not extend to supplanting the court as the decision maker. The fact-finding judge cannot delegate the decision-making role to the expert. Now, I appreciate that I've got to address the question more fully of fairness, and I'll be coming to Brown and Dunn, but it's that delegation which is impermissible, that, with respect, my learned friend's submission to the effect that uncontroverted evidence must be accepted, other than in an exceptional case where it can be shown to be manifestly incredible, that is the problem. Now, my lords, I'm next going to address Brown and Dunn, I accept at the outset, as we've set out in our case, that the rule is not an inflexible one, and moreover, it's clearly moved with the times, and one sees that from the various cases that we have cited with paragraph references in our written case at paragraph 13, which is at page 96 of the bundle, and I'm not going to take you to those. They are all authorities for the propositions, either one or both, that it's a flexible rule or it's not an inflexible one. And also they provide support in two instances for the proposition that its application now falls to be considered in the modern litigation landscape, because after all, the time when it was decided, witness statements weren't exchanged, and therefore notice of what one party was saying wouldn't necessarily have been enjoyed by the other party. And of course, procedural rules now provide not only for the exchange of witness statements, but also expert evidence and other procedures which experts go through if there are experts on both sides. What matters, I entirely accept, and is made clear by the authorities, is procedural fairness. And as was pointed out in Chen, to which you were taken, at 54, which is at 3:30, if a question arises as to whether particular grounds for rejecting a witness's evidence were or should have been put to the witness, ultimately the question is whether the trial overall was fair. Now, I would add, as I've already submitted, that it may be material to distinguish between rejection of evidence in the sense of express rejection, most commonly in order to prefer evidence put in by the other party, on the one hand, and finding evidence insufficient to discharge the burden of proof on the other, a point which I've made, but to which I will return, and which, in my submission, was the position in this case. Similarly, you've been shown Edwards' Life Sciences, and you've been taken, among other passages, to paragraph 65. And again, in the interest of saving at least a bit of time, I won't take you back to that, but I may look at it later. In the context of an expert witness. And it was noted in that case that fairness involves both fairness to the witness, whose honesty or professional reliability, words which I respectfully emphasize, is challenged, but also the overall fairness of the proceedings for the parties.
Is there a page number for that? Sorry.
Yes, it's 473, my lord. If my lord would like me to take you to it now, I perhaps will in a moment for another reason. Now, in the modern context of civil litigation, fairness may be achieved in various ways, including a combination of some or all of the things I mentioned a moment ago. So the normal procedural steps comprising variously exchange of pleadings, statements, expert reports, if there are reports on both sides, or at any rate the service by one party of an expert's report, and of course skeleton arguments, by which means the parties are likely to have notice of the case they face, which would not have been the case, at any rate to the same extent, when the rule in Brown and Dunn was articulated in the 19th century.
Well, there were pretty strict rules about pleadings at that stage.
Pleadings, yes, my lords. We may have gone the other way with pleadings.
I agree, they probably didn't go in for skeleton arguments.
No, but I don't think they went in for exchange of proofs or witness statements either. So I think there were, with respect, quite material differences, and I think cases were also called on quite short notice and didn't occupy as much time and so on and so forth, and just weren't prepared in the same way as they now are. But I don't seek to draw any particularly precise analogy. Simply, I make 2 points. I mean, that is illustrative of the fact that the rule has and must move with the times, but it's also fair to say that parties to modern litigation are far more likely to have notice of what the other side was saying than they were in the 19th century. But it all depends on the type of case as well. Can I just give you 2 references for the observations that have been made about the modern context of civil litigation and how that has affected the rule in Brown and Dunn? One is SATE in the General Medical Council. That's at 1197. And the relevant paragraph, Mr. Justice Mostyn's judgment, is at 1210, and it's paragraph 46.
Sorry, it's
1210, paragraph 46, my lord.
Paragraph 46.
46, sorry, 46.
Yes.
Sorry.
Thank you.
And the other is Williams and the Solicitors Regulation Authority, in which the judgment of a panel of 2 was given by Mr. Justice Carr.
Well, just before leaving,
yes,
121046.
Yes.
In this case, it is possible to conceive that the pleadings, witness statements, and the skeleton argument which was made available the night before the case started.
Yes, well, I accept that, of course.
Yeah,
Yeah,
right.
of course.
Sorry.
But my
late in the day.
well, it was late. It was late, and I'm sure my learned friend is sorry that it was late. But there were any number of other ways in which the defendant's case was set out.
I mean, do you disagree with the second sentence in paragraph 46? The modern system requires all cards to be put face up on the table, and forensic ambushes are basically impossible.
My lord, may I just take the... I'm grateful. The modern system certainly encourages, whether it requires it in all eventualities, that might be putting it too high, but certainly encourages a cards face-up approach. And forensic ambushes are basically impossible. I think what Mr. Justice Mostyn there clearly meant was, bearing in mind what had preceded it, was that nowadays litigation does enjoy the steps that I've already referred to.
Yes, well, I wonder if that sentence may be slightly overstated as a reflection of reality.
Well, I got close, I think, to saying almost that without accepting or conceding that's quite the case. What I think Mr. Justice Mostyn was at pains to say in this case was perhaps clearer or more clearly expressed in another case, which, my lord, is yes, my lords. Is it at 1-1? No, that's not the case. My lord, can I come back to it, because there's another case in which Mr. Justice Mostyn gave judgment and alluded to the same.
Certainly.
Sorry. What's the page? 685. I'm told. I'm great. Yes, yes, that's it. AO, I'm very grateful. 6, the judgment starts at page 685, and the relevant passage is at 699. It may be that this doesn't add a great deal. It's at 63. Nor should the so-called rule in Brown and Dunn mean that there has to be cross-examination if a party is asking the court to disbelieve the other party. In that case, Lord Herschel held that a witness cannot be ambushed by a previously unadvertised allegation of dishonesty. He stated in effect that a witness must be given a fair opportunity to deal with the allegation by it being put to him in cross-examination. And there's reference to a case in the Court of Appeal which Mr. Justice Mostyn suggests was referred to his judgment in state with seeming approval. He then says what we've seen in the other case. If I'm wrong and this rule subsists, there can be no question of it derailing summary proceedings. This was a summary proceeding case. No, my lord, it probably doesn't add a great deal. I think what he was at pains to say in the case, which, and it may or may not overstate it, is that the rule, as originally articulated, has now to be seen in the context of the modern litigation landscape. And on any view, and this point is perhaps better made without reference to authority, but just as a matter of common sense. On any view, the procedural steps that there are, one would hope, do at least make it clear to the respective parties what each one is saying.
Well, that presumably has to be tested on a case-by-case basis.
I accept that. I accept that.
To say that the modern regime will inevitably and always exclude forensic ambush seems to me to be counsel of unwarranted perfection.
No, I don't go that far, my lord. I accept
and here, your client had their attempt to put in an expert's report on this issue refused, and only served a skeleton argument indicating what their real challenge to the professor's evidence was on the night before the hearing, when it was obviously too late to get him to attend by that stage.
Yes, yeah.
So even if Mr. Justice Mostyn's general view may carry some weight, it doesn't seem to have worked in the present case to prevent an ambush.
Well, my Lord, all of that presupposes is that there was nothing else that put the claimant on notice, and my respectful submission is that there was. But, my Lord, just to be clear, there were two categories of expert evidence, microbiology and gastroenterology. Yes. In the one case, we chose not to adduce any. In the other, we didn't get relief from sanctions. So it wasn't just the one.
Okay, but then the other one you chose not.
It doesn't alter the principle, but I didn't want the court to consider that we were only in.
But the one that was directly opposed to Professor Pennington was the one you didn't get permission to deploy, as I understand it.
The microbiology evidence, I think, was the one that we did not serve, actually.
Oh, maybe.
Yes. Yeah. But my Lord, it matters not, but I didn't want the court to proceed on the basis that it was only one expert. There were two. So, my Lord, that's, if you like, what I would say generally about Brown and Dunn and how, to some extent at least, it needs to be viewed in the context of the contemporary litigation landscape. What I would submit next is that whatever the precise status and scope of the rule nowadays, review of the authorities is instructive. And, my Lords, I can tell the court that if one puts Brown and Dunn into Westlaw, you get about 79, I think it is, or anyway, high 70s cases citing it, all of which we've done our best to look at, and many of which are in the bundle of authorities, and I'm sure the other side have done something similar. But what emerges from that review is this, in my respectful submission, that review of the authorities clearly shows that the circumstances in which it has been said or argued that the rule, as interpreted in modern cases, applies, have generally fallen into one of, I think, four categories. Allegations of fraud or dishonesty, so very serious allegations. And in that context, the two cases that I've just referred to, Sate and Williams, for the purpose of explaining what was said about the modern litigation landscape, were cases in which very serious allegations were made, in those cases against professionals. So allegations of fraud or dishonesty. Other serious allegations, for example, allegations of unlawful discrimination or bad faith. Thirdly, what I'll call the paradigm case, with which Brown and Dunn itself was concerned, in which the tribunal is asked to disbelieve a witness, because that with respect, is what Brown and Dunn was about. Untruthfulness. And then fourthly, and this is important.
Well,
sorry.
Do you mean deliberate untruthfulness, or, I mean, for example, because the witness has a very poor memory?
No, I mean untruthfulness. Where what Brown and Dunn itself was concerned with was impeaching a witness by putting to them that they were lying, or that's what should have been done anyway. It wasn't done. That's what it was concerned with. Untruthfulness in the positive sense of telling an untruth, of lying.
So, lying.
Lying.
Right.
What might be called credibility, but I don't mean the sort of thing my Lord has just put to me, which might be more reliability.
Okay.
Is that, I hope that's sufficient.
Yes, thank you. I'm just anxious that these rather vague words, where we're all thinking they mean the same thing.
Yes, of course I'm trying not to use vague words and managing to do so, I'm sorry, but I hope that's
Perhaps one can look at the word used in Chen and Ning, which is accuracy.
Well, my Lord, I'm going to have to come back to that. No, I am, because I don't accept that there the court was propounding the rule in a way that is applied to all inaccuracies, because again what the court was looking at there was positively disbelieving in the sense that I'm talking about the witness. But that was the case in Brown.
I don't want it now, but at some stage I would welcome an explanation why in principle a lapse of memory or other cause of inaccuracy is different from dishonesty. But I'll let you come on to that.
Well, I will come on to it, but the short answer, my lord, is it doesn't involve an imputation on the person's character. It doesn't besmirch their character in the same way as putting to them that they were lying. And it's character that one sees in Brown and Dunn itself being referred to. Anybody can forget something.
What you might be criticising, you might be impeaching, to use another word, an expert witness's expertise.
Oh, you might be saying, look, you're incompetent. You don't possess the relevant ability and expertise, and this is not worth the paper it's written on. You might be saying that. We weren't saying that about Professor Pennington. What we were saying was not in any way challenging his qualifications or ability, and I accept he's an eminent expert. What we were saying was that his report did not cover what it needed to cover.
But in a case where that imputation was made, or that criticism was being made, why should it be in a different category?
But, my lord, if the rule extends to every case in which you're saying that a witness hasn't said enough to prove X or Y...
no, in a case where you're attacking competence of an expert in his claimed field of expertise,
yes,
isn't that as serious, or almost as serious?
It could be. It could be, my lord, but it's not what we were doing.
We're talking across purposes.
I'm sorry,
I'm trying to test the proposition at the moment as your submission as to the extent of the principle.
Yes. I will be taking you back in just a moment to paragraph 65 of Edwards' Life Sciences, where it was concerned with the sort of imputation to an expert that would, I submit, fall within the scope of the rule. And I suppose, could be a fifth category of case, but what it would be akin to would be a serious allegation. And I've given as examples of serious allegations unlawful discrimination or bad faith. It might equally be putting to an expert, you're a charlatan, you're not really qualified to give this evidence, or, you know.
I'm sorry, I interrupted you. I don't think we haven't got the fourth category.
Yes.
No, you haven't, because my lord did interrupt me.
You were interrupted before Lord Lloyd Jones.
But it matters not. I'm glad to be reminded so that I can give it to you. And it's this. A situation in which a party puts up, or advances, forgive me, a positive case which it invites the court to accept, but does not put it to the relevant witnesses called by the other side. And we've seen a couple of examples of that. Now, those 4 or 5, if you want to carve out experts.
I'll make sure I got this last one. A situation where a party advances a positive case which
is not put to the relevant witness on the other side. So if, for example, you have an expert who has a theory as to how something happened, and you don't put that to the other expert.
Yes.
And in this case, you're advancing a positive case that you can't rule out the possibilities that...
No, well, my lord, that with respect to semantics, forgive me, but what we were saying was you can't prove your case because there are various possibilities. We were not adducing evidence of anything leading to the conclusion that it was in fact one of those other possibilities that caused the illness or illnesses.
Why did Lord Halsbury refer to credit and accuracy of facts they have been deposed to, as opposed to honesty in the sense of knowing something is false and lying about it? It's page 306 to 307.
Great. Well, my lord, can I just go back to Lord Herschel before I get to that? Because I think it's important to appreciate what Brown and Dunn itself was about. What Lord Herschel says in the third paragraph of his judgment is, and this bit wasn't read to you, I cannot help saying that it seems to me to be absolutely essential to the proper conduct of a cause where it is intended to suggest that a witness is not speaking the truth on a particular point, to direct his attention to that fact by some questions. And then further on at the bottom, about 5 lines up, my lords, I've always understood that if you intend to impeach a witness, and it's in that sense clearly that he's using the words impeach a witness, you are bound whilst he's in the box to give him an opportunity of making any explanation which is open to him. And as it seems to me, that is not only a rule of professional practice, the conduct of the case, but is essential to fair play. And then on 301, about 5 lines from the bottom of the paragraph beginning, the paragraph ending in the middle of the page, 5 lines up from that, all I am saying is that it will not do to impeach the credibility of a witness upon a matter on which he has not had any opportunity of giving an explanation, by reason of there having been no suggestion whatever in the course of the case that his story is not accepted. By story not being accepted, he clearly means lying. Now, when we go then to Lord Halsbury, starting at 306, 5 lines up, to my mind, nothing would be more absolutely unjust than not to cross-examine witnesses upon evidence which they have given, so as to give them notice and to give them an opportunity of explanation and an opportunity very often to defend their own character. And this is all in the context of what this case was concerned with, untruthfulness. And not having given them such an opportunity to ask the jury afterwards to disbelieve what they have said, in that sense, my lords, although not one question has been directed either to their credit or to the accuracy of the facts they've deposed to. Now, all that he meant there was there hasn't been a question either to their credit, in the sense that it's intended here and what the case was all about, or even to the accuracy. My lord, that would be my answer. That must be what he meant in the context, because this case was nothing to do with the accuracy. In the sense of accuracy as distinct from truthfulness or reliability.
If I take you back to the categories you gave,
yes, my lord.
I think you were asked by my Lord Jones how one could justify them in terms of principle, and you said, well, they're all to do with besmirching the character of the witness, I think. Well, or something
I
similar.
did in response to that question. I mean,
yes.
my answer would be they all involve serious allegations, effectively.
But the fourth of your categories doesn't seem to fit that.
No, positive case is a different matter, but the point there is that you are positively asking the court to find for you on an evidential basis which you've not given the other side the opportunity to address. Now, the difference between that and this case is that we did not do that. We simply asked the court to look at the case advanced, that this was food which caused the illness or illnesses, and find that that case was not made out. So there was nothing positive by way of alternative that had to be put. So the better answer to my Lord Lloyd Jones would have been that they're all concerned with either serious allegations of one sort or another, or inviting the court to accept a positive case which has not been put to the other side.
And how yes, you're saying all you did was put the claimant to the proof?
Yes, I would, exactly that. And this being a case where there were manifold competing causes, and I'll obviously have to come back to this, of the illness or illnesses suffered by the claimant, it was necessary for the claimant to prove what it was that caused his illness. And it was only if it was food that he wouldn't have to prove additionally that there was fault or negligence. Because if it had been the swimming pool, matters would have been different, or if it had been some surface he touched, matters would have been different.
So your categories, Brown and Dunn categories, don't include lack of memory?
No, they don't.
And they don't include, for instance, being influenced by others?
No.
Or they don't include
my Lord,
inconsistent statements?
They don't, but they're not categories of things that have to be put in cross-examination. They are, what I tried to make clear was that review of the authorities revealed that Brown and Dunn had been applied or argued to be applicable in these category of cases. So I'm only concerned with Brown and Dunn requirement to cross-examine on a point, not familiar territory of seeking to cross-examine a witness in order to persuade the judge that they're confused in their recollection, or they can't remember, or they're misremembering something.
But if a witness says, I clearly recall 10 years ago, one starts to wonder, 10 years ago, X happened.
Yes.
And nothing is said or done to indicate that the reliability of that witness's memory is not accepted. Why is there some different rule about whether he should be cross-examined than if you're saying he's...
Well, my Lord, it may be that there is some rule that is broader than Brown and Dunn that requires cross-examination in that case, and I'm not suggesting you wouldn't have to cross-examine in that case, because if you didn't, what the witness said would be accepted by the judge. All I'm submitting is that review of the authorities, insofar as they have considered or touched on Brown and Dunn, reveals that the rule, specifically, has been applied in those categories of cases, and I found no other instances of its application than those categories which I...
Well, just assume that there's an uncertainty about whether Brown and Dunn does or doesn't apply to a challenge based on having a forgettery rather than a memory.
Yes.
I mean, what submission of logic do you want to put forward to say that the principle in that case you should cross-examine him applies just as much as if you're saying he's lying?
Well, my Lord, my answer might be slightly different.
Basis for him understanding that you're impugning, challenging the accuracy of his memory.
My Lord, you would be stuck with a witness's evidence to that simple effect that I remember X or Y if there was nothing else that could be put to him and no other evidence. I mean, the judge would be bound to accept it. But that's different to an expert opinion which depends, for the purpose of deciding whether or not it does make the case and can be accepted, upon a consideration of the reasoning which supports it.
Well, that's moving away from, I think, His Lordship's question, which is, let's leave the expert aside at this moment and let's just focus on a witness to fact. What is the principle for excluding a rule such as the rule of Brown and Dunn in the context of a witness to fact's forgetfulness?
Well, my Lord, I'm not submitting that there is no such or similar rule. I don't think I can do that. If you're going to invite the court to find that a witness is mistaken in their recollection, you might be able to do that by reference to a document that, had it been put to the witness, wouldn't have made any, it couldn't possibly have affected it because he wouldn't have been able to answer it. So in that case, you might not have to cross-examine. But if there was no document that made it obvious that the witness was wrong, then the judge would be bound to accept the answer.
No, I mean, this is a 10-year gap. A witness is recalling. The very first question in cross-examination is, what were you doing the day before?
Yes.
And the witness may provide a very good answer as to what they were doing the day before, or they may not. And they may provide a very good answer as to why they have an absolutely compelling memory as to what occurred 10 years beforehand.
They may not.
And if you're challenging that memory, why is it that isn't also one of your exceptions to Brown and Dunn?
My Lord, they're not exceptions to Brown and... I'm not addressing exceptions to Brown.
No, you're saying it's out with the strict scope of Brown.
Yes, I am.
Outside the scope of. Then why is it not? Why is it outside the scope of?
Well, a similar rule to Brown and Dunn, but might well apply in those circumstances. And as I've just submitted, if you're going to make put to a witness that their memory is wrong, then you need to challenge on that, and the judge may very well not be prepared to do anything other than accept the witness's evidence if you don't. But there might be a case where you'd be excused from doing so if there was a document, perhaps authored by the very witness, that made it absolutely plain their memory was wrong, and had it been put to them, they would have been bound to accept it. But, so the principle that you would have to put it, if that is what we're talking about, would apply, my Lord.
I take it from that lack of memory is not outside the scope of Brown and Dunn.
that it would otherwise be unfair to invite the court to disregard the evidence. No,
Yes.
that must be right, my Lord.
Yeah. Okay.
Forgive me, my Lord, I may have been at cross purposes with the court. All I was focusing on, or trying to focus on, perhaps not in a very helpful way, was those cases in which Brown and Dunn itself has been considered and found to apply.
Yeah. But those other cases weren't expressing a rule that Brown and Dunn was limited. It was just dealing with particular examples, as far as I understand it, in which it applied.
My Lord, yes. My Lord, I'm going to be saying something a little bit later about another aspect of Brown and Dunn. Can I come back to that?
Please do.
I'm grateful. So, my Lord, I was just on the scope of the rule nowadays and what the authorities show. And I said that I would take you back for these purposes to Edwards Life Sciences briefly. It's at 456. That's right. And the relevant paragraph, which is paragraph 65, is at 473. Secondly, I would agree as a general matter that the rule requiring important positive evidence to be challenged is a rule which is not simply for the benefit of the witness whose honesty or professional reliability is challenged, but it is also designed to ensure the overall fairness of the proceedings for the parties. My Lords, all I take from that is that what appears to have been envisaged by the court is that the rule would apply where honesty or professional reliability is at stake. Now, my Lord, I will have to come back to your question, and it may be that I will, when I return to it, seek to distinguish between the examples that I have given, and which I've taken from the authorities, and the example my Lord has put to me. But for present purposes, that is the only guidance of any sort, and it's not really guidance, but indication of the sort of thing that might be in play in terms of the rule in Brown and Dunn when it comes to expert evidence. Now,
would you
clearly,
accept that it's implicit in paragraphs 66 and 67 read together that is it Lord Justice Floyd? I can't remember who's speaking, but whoever it is assuming that the rule applies to expert evidence, but simply giving examples where the unfairness, the potential unfairness, is remedied by other procedural steps.
yes, it's Lord Justice Floyd, my Lord.
Yes,
Well, my Lord, that's possible. I mean, at 66, what clearly Lord Justice Floyd is addressing is the situation in which it's proposed to invite the court to disbelieve the evidence. It's that demands that there should be a challenge. And then in 67, not every situation, however, calls for a rigid application of the rule, and it may be that I'll be making some such answer to my Lord Stephen's question when I return to it. But
this was about not challenging expert evidence.
It was. It was. Yes. I mean, what I suppose one gets from 67 is, in the second sentence, is that at least part of the unfairness which the rule is intended to address is the lack of any opportunity for a witness to respond to a challenge to his evidence. Then it goes on to explain how in this case that was mitigated by the fact that there'd been an opportunity because there'd been rounds of expert evidence and the like. But that is all in a very different situation to the situation with which the court was faced, Her Honour Judge Truman was faced in this case, because all she was being asked to do, and I'm at risk of saying it until I'm blue in the face, but was to determine whether or not the claim based on the evidence adduced by the claimant, when properly considered, was proved on the balance of probabilities.
Taking the paragraph 65 to 67 together, what Lord Justice Floyd seems to be envisaging is that one considers not just the interest of the witness and his or her honesty and professional integrity, but also the interest of the parties in a question of procedural fairness.
Yes.
And included in that is the lack of an opportunity of a party's witness to respond to a challenge.
Well, that's true, albeit in this case the rule wasn't infringed because of the various reasons set out in great detail at 70. So, I mean, this wasn't a case in which...
Not in this case.
No.
But as to Lord Justice Floyd's understanding of the scope of the rule, I think it does extend beyond the witness to the parties. Procedural fairness is something in which each party to a case has an interest.
Yes, I think that much must be clear from the way the rule was articulated in Chen and Ng as well, because procedural fairness must encompass fairness to the parties, not just to the witness. And then there was the point made by my Lord Stephen that it may also include fairness to the court. He's got to try the case. And
that's been my experience.
Well, and I'm sure that's right, my Lord. But again, the demands or the requirements in that respect may be very different in a different type of case to this case, where, for instance, you've got competing expert evidence. Then the judge trying the case will be put in a very difficult position if there isn't cross-examination and interrogation of the evidence, so that the judge.
Even if there isn't, the judge may have his or her own questions about the reasoning, which the absence of the expert makes it impossible for the judge to pursue.
Well, my
I'm
Lord,
not sure what the answer to that is, because there's an obvious procedural advantage for the parties in not incurring the expense of an expert turning up merely on the off chance that the judge may have a question.
Well, that may be part of it, but the more fundamental point, my Lord, is that I'm afraid that whilst the judge may have burning questions that they would have liked to ask, that only arises if the witness is called and is there to be cross-examined and therefore asked questions by the judge. If the defendant's position is, or the claimant's indeed in a different type of case, that you simply can't get from this evidence what is required to prove the case, then the judge might have liked to ask some questions, might have thought that questions would have led to a different answer, but it's nothing to the point.
Well, that is Mr. Weir's point about the adversarial system sometimes tying the hands of the judge.
Well, my Lord, one has to be a little bit careful about that, because we do have an adversarial system, and that can put the judge in a difficult position, but we also have a fundamental proof, a fundamental principle, namely that the burden is and always is, save in exceptional cases.
You still have that point, and I know you wish to develop it, and
yes.
That's fine, but I think the point you're making is that sometimes the judge may have some burning questions, but not be given the opportunity to put them, and that's just the way litigation works.
Well, it is, and it would be wrong to characterise that as something which has arisen from the failure of the defendant to make an application to cross-examine the witness, if in truth it's a failure on the part of the claimant to adduce sufficient evidence to prove the case. My Lord, is that an appropriate moment?
Would that be a convenient point too?
It's as good as any point.
Well, that's indeed fine. Thank you very much. The court will now adjourn.